Thank you very much. Thanks for letting me talk to you, everybody. So it's Friday afternoon. You just heard about DNA evidence from a guy who is a lot smarter than I am. There may be a little bit of fatigue setting in the room. So I guess I'm gonna try to, first of all, get you guys back on time. But second of all, put a little bit of energy into the room with a quick informal poll. I'm just curious, how many of you regularly practice criminal law in federal court? A few. How about state court? A lot. All right, how many people are here because your CLE is due tomorrow? Okay, no shame. I've been in that situation. Because the federal practitioners are probably a minority in this group, I thought I would just start by giving you a little bit of background about the U.S. Attorney's Office, and my apologies if I'm insulting your intelligence, but not everybody is as familiar with our work as obviously I am. So we are the federal government as it relates to criminal law in the Southern District of Iowa. We prosecute all criminal cases that happen in our district. We also defend the United States in all civil actions in our district. We are one of many offices. There are 94 U.S. Attorney's offices across the country. There's at least one in each state. Iowa has two. We have a northern district and a southern district. You all are in the southern district. Congratulations. I am partial to our district. Most people would divide Iowa by eastern Iowa and western Iowa. For whatever reason, our two districts are north and south, and the rough dividing line is Highway 30, kind of right in the middle of the state. I am a career prosecutor. I'm in a politically appointed position, but I've been a prosecutor my whole career, both here in Des Moines and before that in Chicago. And I am very proud of our office and the work that we do. I'm going to talk about two basic things today. The first is our priorities as an office, and the second is our charging policies. Even though I'm standing behind this lectern and lecturing to you, I don't have a fancy PowerPoint. If you have questions, raise your hand or just shout them out as I go along. I will not be offended. First on our priorities. So the top priority for our office is violent crime. We are particularly focused on gang-related violence in Des Moines and Davenport. This is a national priority for the Department of Justice, and it's driven by some concerning trends we've seen in violent crime rates over the last few years. From 2015 to 2017, the homicide rate nationally rose about 20%. A lot of that rise was driven by murders in a few very large cities like Chicago and Baltimore and St. Louis and Memphis. But we have seen a troubling trend in Des Moines and in Davenport as well. So compared to many of our neighboring states and cities, Iowa remains a remarkably safe place to live, and we are all very thankful for that. But the murder rate in Des Moines and Davenport approximately doubled from 2017 compared to the previous year. That is a concerning trend. Many of those murders are gang-related and involve firearms. Nearly all of the homicides in Davenport were gun-related, and many of them were gang-related, and that is also true in Des Moines. Because of that, we are being as aggressive as we possibly can about prosecuting federal gun crimes in our district and about targeting gangs, identifying the most violent neighborhoods in our community and the most violent people in our community, and charging them with any crime we can prove, federal, state, or otherwise. So that is a huge priority for us. Another priority is sort of a general category of cases, and that's crimes that involve vulnerable victims. There's a few different pieces of that. One is elder fraud and abuse. Our elderly population is vulnerable to lots of different types of crimes. They're vulnerable to neglect. They're vulnerable to failure of care in our nursing homes. One that is of particular interest to me is fraud schemes, scams that tend to victimize the elderly more than other groups. We see a whole range of those schemes. Many of them involve actors that are outside the state of Iowa or outside the country. These lottery schemes, you've won $10,000, all you need to do is wire us $1,000 first and you can claim it. The call telling you that your granddaughter has been arrested for drunk driving and you need to send $500 to bail her out of jail. If my grandmother had gotten a call like that, she probably would have thought it was fairly plausible and may have, unfortunately, acted. Those scams sweep up the elderly more than they do others because they're more vulnerable. And when they happen, folks are often embarrassed to talk about them or embarrassed to admit that they were fooled. There's also a whole category of crime involving people who have power of attorney over relatives and elderly relatives' finances and abuse that power to spend the money on all manner of things that is not for the well-being of the elderly relative. These are things that we are on the lookout for and targeting, and in particular fraud schemes that cross state lines. If the federal government doesn't do them, typically those cases will not be prosecuted, and therefore they are a significant priority for me and for our office. In that general cluster of vulnerable victims, I would also include child exploitation offenses of all kinds. We're particularly focused on crimes in which there's a hands-on offense, but any offense in which a child is taken advantage of sexually. We have a lot of very powerful tools and very stiff penalties to prosecute those. And then the last one that I'll mention is human trafficking, which when people think about human trafficking, that can mean a lot of things to a lot of people, but it is absolutely happening in Iowa in a variety of forms, from gangs who are trafficking women as a means of making money for their criminal group, as pimps who are bringing women from Chicago or from California on a circuit that has them traveling through Iowa. We prosecuted a case recently in which a man pimped out a 14-year-old girl and a 16-year-old girl in exchange for drugs. Both of them, those young women, were family relatives of his. He was sentenced to life in prison for that offense. Those cases can be difficult to investigate and prosecute. They often, again, cross state lines. They involve some of the most vulnerable people in our communities, people whose voices are often not heard. It is a huge priority for us to prosecute those cases as well. The last area I'll highlight is drugs. The opioid epidemic has not crashed. That wave has not crashed on top of Iowa the way it has some other parts of the country, parts of New England, Appalachia, the Rust Belt. But if you talk to our police chiefs in the Des Moines Metro, certainly, and really across our state, they are seeing more overdoses, more overdose deaths now than they did 5 or 10 years ago, and those numbers are only going up. Many of those cases involve heroin that is laced with fentanyl, which is just an unbelievably lethal substance that kills our citizens far too frequently. We are focused on those cases. When we have overdoses, we are trying to work those as crime scenes so that it's not simply a medical event, but rather a crime that occurred there, so that we can work back on who supplied the heroin that led to the overdose and who supplied that person, and back up as far up the chain as we can work. We had great success with one of those cases arising out of the Carter Lake area where there was an overdose resulting in death, and we were able to identify a network of people responsible for supplying it, and several of them have gotten federal sentences that measure in the decades. While heroin and opioids is a national an issue with national attention, we still have and have had for decades an enormous meth problem in Iowa. That has not abated. In fact, the methamphetamine, we used to have meth labs in Iowa that were very common. Those are very uncommon these days. Instead, almost all of the meth is coming from Mexico. It's coming 95 to 100% pure in most cases. It's relatively cheap, and we are seeing it in just astonishing quantities. A recent takedown that our office did involved the seizure of between 40 and 50 pounds of meth, something like $400,000, and at least 10 to a dozen firearms. This is just from one case, and people operating in relatively small towns in our district. So the meth problem, I'm sorry to say, has not gotten any better. It continues to get our attention. Those are our priorities. I'm going to pause for a minute and let anyone ask me any questions about them that you have. Yes, sir.
851 notices.
Yes.
What is your philosophy or procedure on when they are filed, if a defendant is 851 eligible, at the beginning with the indictment, later on negotiations aren't going smoothly, how do you look at 851 notices?
Great question. And for the rest of the room who has no idea what an 851 notice is, for federal defendants who are charged with a drug felony who have a previous drug felony, we can file a notice notifying the defendant that he has that prior felony. That can, in many cases, double the mandatory minimum penalty that he's facing. So, for example, in a fairly common meth case, a defendant many of our defendants face at least 10 years in prison no matter what on those cases. If they have a prior drug felony, we can double that to 20. That's a very common scenario. So my view on it is this. We typically, in most, if not, I would say nearly every case, will file an 851 where we can prove that prior conviction exists. We will file it within 30 days of the arraignment, so of charging. As a general practice, I don't think I'm giving away a state secret to say that you will notice a trend that we have not been filing. Oh, by the way, if somebody has 2 prior drug felonies, that is a mandatory life in prison. So that's obviously hiking things up very significantly. Thus far, as I started in October, we have not filed multiple 851s to trigger mandatory life. I'm not saying we wouldn't. I'm saying we haven't done it so far, and so you can glean whatever you want from that. So we'll typically file 1. In many cases, we will dismiss it, particularly if there's cooperation. We want to use the 851 notices as I would call it an encouragement and incentive for folks to cooperate with us and give up their suppliers and their drug distribution networks. In some cases, we will dismiss it in the course of plea negotiations. Every case is different. We are open to discussions about dismissing those. There are going to be cases where we're going to be less anxious to dismiss them, where the defendant is a career offender and his guideline range is higher than, is significantly higher than even the 851 range. So the short answer is we file them. We file them early. We're only filing 1 in most cases, and we're open to discussion about whether to dismiss them. That occurs as part of either cooperation or sometimes plea negotiations. Does that give you a general sense?
Policy is to file early, and you would have the policy against, implicitly what you said, filing it, say, a few days before the trial.
That's correct. Yeah, it is not our practice to file these on the eve of trial. Any other questions about that? So that leads to our charging policy. The 851s are obviously a part of that. Our general charging policy, and this is the department's charging policy, it's not unique to our district. It's very simple. In most cases, we charge the most serious readily provable offense. That means we charge the crime that we can prove and that carries the most significant penalty. Some version of that policy has been department policy since the Carter administration. It was briefly not the policy in certain drug cases during the last half of the Obama administration. It is now, again, the policy of the department. There are exceptions to that rule, and the policy makes very clear, and something that's important to me, that our prosecutors have to evaluate each case individually and determine what is the right result in that case, which means that we are not always going to file the most serious charge, though the trend is going to be pretty clear that most of the time we're going to file the most serious charge. That's another issue where we are open to conversation with defense counsel about whether a less serious charge is appropriate because justice requires it, and we are happy to have those conversations. I want our prosecutors to be doing that analysis in their cases. That's really the crux of our charging policy. It is a relatively simple one. I've got a few minutes left, and I'm happy to answer any questions that you have about any topic, including ones that I did not cover. Yes, Andrea.
When it comes to sentencing policies, what kind of policies does your office have in place for sentencing negotiations, in particular defendants' objections to PSRs, and whether that constitutes a failure to accept responsibility or relevant conduct for sentencing purposes.
So PSR, for those who aren't, I think that probably the term is similar in state court, is pre-sentence investigation report that's prepared by our probation office. So some of this is obviously provided for in the guidelines. I believe there's plenty of room for reasonable people to disagree about guidelines enhancements. I frequently agree to disagree with defense counsel about guidelines enhancements. That happens commonly. Obviously, the guidelines, as you know, contain a provision that when defendants frivolously contest certain conduct, that could mean that they're not accepting responsibility. My personal view is that those are the rare occasions, and that every time we're fighting about the guidelines is not a matter of trying to yank someone's credit for acceptance of responsibility. I will say, though, that in terms of the guidelines, I guess I have a view that the government shouldn't fact bargain in order to reach plea agreements. And by that, I mean, we shouldn't agree not to pursue certain enhancements that we can prove, that we can credibly prove just in order to get an agreement. If we should seek the guidelines enhancements, and these are the federal sentencing guidelines, that we think apply. And if that results in a sentencing range that's too high, that's not fair, that's unjust, we should then ask for a variance rather than playing with the guideline calculation to start out with an artificially low number. So that's my personal view, and I think the view you'll see reflected by our prosecutors. Yes?
Only a couple times in my career have I not been able to work through plea negotiations with the AUSA I'm working with.
Right.
But a couple times I've said, we're not on the same page.
Right.
Let's invite the first assistant or the chief of criminal
Yep.
to join in the conversation. Is that something you're open-minded to in your office if there's an impasse for whatever reason and both parties are trying to resolve it through a plea agreement?
Yes. The short answer is yes, and the long answer is yes. I am happy. I agree with you that most of the time these conversations are best had by the attorneys, the line attorneys handling the case. But there are going to be cases where either you feel strongly about it, or you feel like our line prosecutors are taking unreasonable views, or for whatever reason you're just not having a meeting of the minds. And I call those pitches. You can make a pitch to whoever you want. I mean, in Davenport, obviously Rich Westfall is your first stop, and a good stop. But I'm happy to entertain those as well. I will hear out any defense counsel on any issue they want to talk to me about. I'm not too busy to do that. I'm happy to do it. As with any other thing in life, if somebody comes and pitches to me about every case and makes bad arguments, then the next pitch is going to be far less effective. But I'm happy to hear defense pitches if you want to make them. And if you want to start farther down the line before me, that's also fine. I'm not offended. I think, sir, you had a question. No, I imagined it.
Not at this time.
Okay, thank you. Yes, sir.
Have you, given it's been a while since the Johnson line of cases, have you seen a slowdown at all with regard to those cases where they're contesting the predicate offenses for ACCA or career offender?
So just a little bit of context for everybody else. This is an incredibly intricately boring, painful area of the law that has significant consequences, because we're talking about whether people have to serve 15 years mandatory minimum in federal court when they're caught with a firearm because of their prior history. The Supreme Court has tinkered with this often over the years, to the great frustration of everyone. The current system, you have to be a medieval philosopher in order to follow it. I was lucky enough to stop doing a lot of gun cases shortly after Johnson and Mathis were decided, moved over to the white collar side, and was very happy to avoid all of that. There was a glut of those cases from many decades past, people bringing 2255s and so on, habeas motions and so on. It has slowed down from the torrent, but it is still an issue we are constantly dealing with. It has consumed an enormous amount of time, and it is a bit crazy in my view. They should blow the statute up and start over. That's not the department's position, by the way. That's my own personal view. But this still continues to be a vexing issue that consumes a lot of time, because you're trying to decide what happened in some case from Chicago from 1991, and is the Illinois statute written in a way that no one can understand. So
Is it still now the refiling of 2055 or filing of 2055, or is it new cases?
it's mostly in new cases that we're seeing it. The 2255s have kind of come after Mathis was the last case that was most significant on this in the Supreme Court. And the cases based on that have been filed, for old cases have been filed. We're seeing it now in pending and new cases. It's 2:31. I intend to stop because that's when I'm supposed to stop. Thank you very much. I appreciate it.